Assalamu alaikum everyone. My name is Muhammad Shahzeb Azam and today I am going to give my presentation on the topic General Principles of International Arbitration. Arbitration together with judicial settlement are the two main methods in international law to settle disputes in a binding manner. Both are what we call legal dispute settlement mechanisms. They contrast with mediation or conciliation because these methods do not result in a decision binding on the parties. The first and the main principle of international arbitration is that the arbitral award is binding on the parties. The binding character flows from the fact that the parties to the dispute, by choosing arbitration to settle their disputes, accept in advance that they will bound by the outcome. For instance, Article 34, Paragraph 2 of UN CITRAL arbitration rules. The second and probably the most fundamental principle of international arbitration is that arbitration is designed by the parties to the dispute themselves. This is called the principle of party autonomy. This implies that it is the parties to the dispute who choose the arbitrators and the procedural law. That is the law that applies to how the procedure will be conducted, and finally, the law applicable to settlement of disputes, the so called applicable law. This principle also implies that parties themselves define the issue or subject matter to be decided by the arbitral tribunal. In other words, the tribunal has the authority or competence to decide only those issues that the parties have submitted to decision by the tribunal. The fundamental principle that the parties choose their arbitrators is the main feature that distinguishes arbitration from settlement by international courts and tribunals. In case of the courts or tribunal is composed of judges that are appointed or elected for a fixed term and not by the parties. Also, the procedure is entirely predetermined and the statutes of the courts and tribunals. The parties cannot, in principle, change these rules. As far as the composition and structure of arbitral tribunals is concerned, parties can choose freely how many arbitrators will compose the tribunal. Typically, tribunals are composed of 3 or 5 arbitrators. Sometimes the dispute is referred to a sole arbitrator or a tribunal composed of 7 arbitrators. For interstate arbitration, the recent practice is to appoint a 5 member tribunal, and for investor state arbitration, the practice is a 3 member tribunal. Usually, the parties themselves each appoint an equal number of arbitrators, that is, each 1 or 2 arbitrators in the case of 3 or 5 member tribunal. The remaining arbitrator, who will act as the president of the tribunal, is appointed jointly by the party appointed arbitrators or the parties. In case of disagreement, an appointing authority usually is identified who will appoint the arbitrator if the parties disagree, or if one of the parties fails to appoint its own arbitrator. The appointing authority, usually the Secretary General of Permanent Court of Arbitration or the President of International Court of Justice, but it can in fact be anyone. It is important to point out that all the arbitrators, including those appointed by the parties, need to be fully independent and impartial. This is contrary to JTT arbitration, where the appointed arbitrators often saw their roles as an extension of diplomacy. Independent and impartiality implies that the arbitrators should not have any ties, family, financial, or otherwise to the parties, and that they have no prejudged the case. In case of doubt as to the independence or impartiality of an appointed arbitrator, procedures exist to challenge these arbitrators. The procedural law is freely chosen by the parties. Here there is distinction between ad hoc arbitration and institutional arbitration. In institutional arbitration, the institution to which the dispute is submitted will function with its own rules of procedure. This means that this choice implies the use of specific procedural rules of that institution. There are, however, exceptions to this principle. A notable example is Permanent Court of Arbitration, which allows parties to use other procedural rules than that of Permanent Court of Arbitration. For ad hoc arbitration, the choice of parties as to which rules they will use is entirely open. Parties are free to draft their own rules, which is the case, for example, for arbitration under the Law of Sea Convention, which has specific procedural rules in its Annex 7. Alternatively, the parties can use existing sets or models of procedural rules. The most important set of rules are the arbitration rules of the United Nations Commission on International Trade Law, UNCITRAL. These rules can be used for interstate arbitration, investor state arbitration, and international commercial arbitration. The rules contain provisions on, for example, the constitution of tribunals, the conduct of the procedure, the powers of tribunals in relation to evidence gathering, and the effect and form of the awards. That's all from me. Thank you.